Good afternoon and welcome to Ask an Expert with Edie Bogacyk about prior written notice. Edie has worked as an attorney for 25 years, but has been an advocate for her entire adult life. After working in a variety of non-traditional legal roles, Edie returned to the practice of law full-time with the intention of working in an area that embraced her passion for disability rights, coupled with filling a community void and need for legal support in special education law. Edie and her husband David have a son who is a senior plus student and a daughter who is a freshman in college. Their son was born with Prader-Willi syndrome and has been a student with an IEP for the past 14 years in the public school system. Welcome, Edie, and thank you this afternoon for sharing your expertise with Ask an Expert.
Thank you, Deb, and thank you, Ask Resource Center. At this time, I wanted to share with you, in case you don't know yet, that the Ask Resource Center has recently sent out a new flyer, informational brochure on the prior written notice. It's a 2-page brochure. It has excellent information. It's kind of the condensed version of the PowerPoint that I'm going to be doing for you today. And also, it's important that as you're going through the prior written notice brochure, that informational pack that you've got from Ask Resource Center, and also my PowerPoint, that you have your procedural safeguards handy, because these two go together, and this should always be close to your fingertips as long as you have a student with an IEP. So we're going to go through the PowerPoint, and probably going to take about an hour, and we're excited to continue this wonderful training session. There's a lot of good information that I'm going to be sharing with you today. So we have prior written notice, a review of parental rights. Before I go into my presentation, I just wanted to share that even though I am an attorney, I'm a special education attorney, I'm going to be probably giving you a lot of ideas in terms of certain circumstances. I'd like to give examples so parents can understand kind of when I apply the law to a situation that might happen at a school. However, at the same time, please do not substitute this information for legal advice, because every situation is different. One small nuance or one fact can change the whole situation of a case. So no two cases are the same, because no two children are the same, because that's why we have the I individualized and IEP and IDEA. So I just wanted to give you the heads up that there could be a lot of differences from your situation to what I might be generalizing. So if you need any assistance, there's lots of legal resources in the community that you can contact. Now, today's objective, and this is geared for students with IEPs, parents and guardians. This is so important that you understand your students' procedural safeguard rights. So when my goal is to have every parent know what PWN means, just as comfortable and as familiar as they know what IEP, the Individual Education Program or Plan. I go to a lot of special education conferences, disability-related conferences, and I often will hear parents talk about IEP. Did you get this in the IEP? Or we have an upcoming IEP meeting. However, I have never heard any parents talk about a prior written notice, the PWN. And you really can't have an IEP without a PWN. So it's so important that my objective is at the end of this workshop and this training program is that the parents will be as comfortable in being able to understand what a PWN, and PWN will also be part of the regular conversations whenever they talk about an IEP, because really you can't have one without the other. They have to go hand in hand, and now we're going to find out why. So how important is a prior written notice? Oh my gosh, it is so important. A prior written notice, PWN, it's a guaranteed legal right to parents, and it is a procedural protection. And you often when you go to an IEP meeting at the beginning, before you even get to any of the discussion of the goals or the background of the student or any of their probes, they always start with procedural safeguard rights and the manual that they hand out. And this is what's part in this manual is the prior written notice there's like about 10 procedural safeguard rights, and this is one of the 10, the prior written notice. And so it is your right, it is your protection. Congress put this protection in there to give parents an opportunity to challenge some decisions that are made by the school district or the AEA. So we want you to know how important that this right is to you, and to understand this right and to be able to use it if you ever need it. Then we have, okay, you've talked about PWN, because I keep wanting to say that over and over, PWN, because like I said, you can't have an IEP without a PWN. What the heck is a PWN? Well, a prior written notice is a written explanation. It's a change. It's a document that will reflect the changes that are made to a student's IEP. And the change is what the notice is. They're going to give you notices that, hey, some changes are going to be coming up, and we're going to be making these proposals of these changes, and you're giving advance notice before anything's actually going to take effect or go into place. So it is a notice of changes. And that's really, I try to highlight certain words, because sometimes, it's, especially when it's new, it can be overwhelming. So written explanation, it's like a document. So thinking, okay, it's going to be a document, and it's going to be giving you notice that some changes are going to be proposed to your child's IEP. Then you have prior. Oh my gosh, this comes up a lot. This even comes up at conferences that I've been to with attorneys, that the word prior is so confusing. And I know I've heard it discussed even at IEP meetings. Why do they say prior when everything's happening after the IEP? Well, the word prior means, hey, this is, again, going back to what Congress wanted to make sure that this procedural protection was in place. Parents are afforded prior notice before any new changes are going to go into place in the IEP. So you're going to have the IEP meeting, and then after the IEP meeting, the school district and AEA, I always kind of combine the two, have a legal duty and responsibility to issue a written notice, a written document to the parents or guardians that we're going to have some proposed changes prior to these changes going into effect. Those changes shouldn't be going into effect that day or immediately. They want to give notice, adequate notice, to have the parents review what was proposed so they can make informed decisions. Now, why is this requirement so important? It's so important because this is what actually triggers your procedural protections. This is what triggers your rights regarding the notice and making an informed decision, but a timely decision. If you have no problems with all the proposed changes, then the prior written notice is going to be something that you're going to take and you're going to file with your child's IEP folder. However, if there are some changes that are going to be made that you're going to want to challenge or contest, then these changes, you're given advance notice that these changes are going to take place. They're going to be implemented at a certain time. And so you're going to want to make some decisions. You're going to have some options before they're being implemented. And we're going to talk later on in this presentation of what those options are. But so now we've got to the point where we have a prior written notice, PWN, after the IEP meeting. Prior written notice is going to be giving you a heads up. It's going to give you notice before any changes are going to place. And you're going to know that there's a timeline, there's a deadline that you as the parent now have this procedural protection, the safeguard right. Now you have to decide, there's a short amount of time of when you're going to challenge it and if you want to challenge it. So where can we find this law? I always think it's important to share with parents where this federal regulation and law can be found, because you can just take that 34 CFR 300.503. That is all the legal information and law about a prior written notice. That is the responsibility and obligation of the public agency, which is the school district, and also sometimes the AEA will issue the prior written notice. I think it's important for you to know where it is, because I've been in situations where I've worked with parents where, they will share with me that they're at an IEP meeting and they'll make a request and they'll just be told no. And when they ask why, somebody on the IEP team will tell them because that's the law. And I want the parents to be able to be self-empowered and know the law and know where to find the law and maybe challenge or, even ask the IEP member, say, well, can you share that citation with me? Can you share what law you're talking about? Because we want to make sure that we're both informed and we're both looking at the same regulation as well. So I love to give the citations when I can. You can just put it in any browser and it should come up. And you can even print out a copy if you want and put it in with your forms or your folder. But I think it's important to know where to find this law. And then this way you can actually see the specific details in case it ever even comes up in a similar situation where somebody just tells you, I can't do that, or why. Now, there's only 8 instances when a prior written notice should be provided. So, and I have to just let you know, and there's only 8. And there could be questions or requests that a parent can make that do not fall within these 8 very narrowly defined situations. But that doesn't mean that those requests or that information can't be documented somewhere else. It could be documented in the IEP, but it means that if it's outside of one of these 8 requests, these instances that I'm going to go through one at a time, then there's no legal obligation of the school district or AEA to issue a prior written notice. So I think that's really important too, to help parents understand what their rights are, but also these rights are narrow. So in number 1, when the school district or AEA proposes to initiate or change the identification. So now we're looking at proposes and identification of a student. So I try to give examples with all of the 8 instances so it'll help you understand how to find what that particular procedural safeguard or that right means. So for example, in this situation, when the school district conducts a screening, sometimes referred to as a disability suspect review, and afterwards, if they propose conducting an initial evaluation, they decide, okay, the student does have a disability, the student has some challenges, we're going to get together and let's go meet with the parents and get their consent. We're going to propose to do an initial evaluation to determine whether the student is eligible or whether special education services are even necessary. So a prior written notice has to be provided to the parents before proceeding. So you're going to need consent, but you're going to need to make sure that they're proposing to do an evaluation, and it needs to be provided to the parents. Because you'll learn later on in the presentation, there's also some requirements that they have to explain why they are proposing such an action. It's not just we're going to propose to do it. There's going to be 7 elements that we're going to talk to after these 8 instances of what has to be contained within the document itself. So number 2, this is the second instance when a prior written notice should be provided. When the school district and AEA propose to initiate or change the evaluation of the student. So this could be, they had the disability suspect meeting, they got consent, they did the evaluation, and the school district and the AEA, they determined that the student is eligible for special education services. So they did a prior written notice. And so this is another example of when you would receive one. Now you have number 3, proposes to change the educational placement of a student. There's several examples here. And I want you to know that in all of these areas, I might be only giving 1 or 2 or maybe 3, but the examples are not limiting. There's lots of other specific examples. So just because your situation isn't expressly stated in my presentation doesn't mean that it's not a situation that doesn't fit within these, that you should be receiving a prior written notice. So in this situation, example, there's a disciplinary removal for more than 10 consecutive days. Prior written notice needs to be issued. Student ends up graduating with a regular diploma. So they're going to be exiting out of special education services. They're going to be exiting out of the school district. They're going to be done. So that is when you would get a prior written notice. Termination of special education services. I see this often, for example, when students might have a speech-only IEP. Then they've met their goals, they've demonstrated that they're proficient, they've closed the gap, the team decides that there's no reason for future services, so there's a request or proposal to terminate special education services. So it doesn't always mean it's a negative thing, it could be a positive thing. For example, the student moving from special education classes into primarily gen ed classes or vice versa. So you're going to be changing a placement there. So here's some examples of educational placement and when you would receive a prior written notice. Now we have FAPE. This is when the school district or area education agency proposes to initiate or change the provisions of a free appropriate public education of the student. So this is, you really don't have an IEP meeting without having some type of prior written notice about this area. Because usually you have to do it's mandatory to do an annual review of the IEP. And you're always talking about the goals. So if they're going to be reviewing the IEP, revising it, deleting or adding a related service, which could be like speech, OT, PT, how about if you increase or decrease special education minutes, or the use of a paraprofessional, you change the annual goals in the existing IEP. Those are situations whenever you're something related to the service and programming in the IEP for the student, those are situations that are mandated for a prior written notice. So you'll be getting one after the meeting outlining all the proposals to FAPE. Now you have number 5. So now before we talk about the first 4 were all proposals for changes. These are now refusals. So the next 4 are going to be refusals. So you have this when the school district or AEA refuses to initiate or change identification of a student. So what if a parent wants to exit the student from special education and the school district determines continued services are necessary? I've had situations where parents, for their own personal reasons, decide that they no longer want their child to be in special education. However, the school district and the AA believe that the child still needs these services in order to receive FAPE. So they're going to probably issue a prior written notice refusing. At that point in time, there's options that both sides could take moving forward. Having the prior written notice and your options are separate that we're going to talk to in a minute, but it's really important to you understand those categories, those 4 categories that we're going through. So there's the identification, there's the evaluation or reevaluation, placement, and FAPE. So those are really the 4 main categories that you're going to have a prior written notice when there's some proposals or changes in those areas. So now number 6 is when the school district or AEA refuses to initiate or change the evaluation of a student. So I see this often, like after disability suspect review. So remember, there's no IEP or anything. They're just doing this initial review. And the school district or AEA decides, you know what? This student does not need special education. The interventions that the teacher is using in the classroom are fine. We don't see, there's no data to support the need for an initial evaluation. So at that point in time, they'll issue a prior written notice. They're refusing the parent's request. This is where I'll see maybe a request for some speech or behavior academic goals, and they'll say no. They don't believe their data supports that they are making progress in the general education classroom. There's no concerns in regards to significant delay. There's all kinds of benchmarks and data that they look at, but they have to demonstrate and be proficient in being able to explain their refusal. But I do see this happening where they sometimes refuse to even conduct the initial evaluation or the parent's request for an evaluation in a certain area. They don't see the need for it. Number 7, this is focused on when the school district or AEA refuses to initiate or change the educational placement of a student. And I see this a lot when you're looking on the continuum of placement. For example, you have a student with significant mental health needs, and parent and the student's private mental health providers believe that the student needs to be maybe in a therapeutic placement. So they go to the school, go to the IEP team, discuss it, and if the IEP team decides or the district A refuses to consider the parent's request for a placement change, then a prior written notice has to be issued. And then again, explaining and outlining why, very specifically provide details why they're refusing the parent's request. And then the last one we have is when a prior written notice must be provided, is when the school district or AEA refuses to initiate a change in regards to FAPE for the student. And for example, the school district or AEA may refuse the parent's request to increase or decrease a related service. For example, the student's currently receiving speech therapy once a week and the parent makes a request for twice a week. And they say no. They believe that school district might believe that they can still make progress in only having that one speech therapy session a week. Or parent makes a request for a one-on-one para instead of a shared para because they see that there's some increase in behaviors or non-compliance by their child. Again, so they're believing that's related to their services and supports, their FAPE. And if they refuse, the school district or AA refuses to add some more support staff or change the hours of or the minutes the support staff is dedicated to the student, then there's a requirement that they issue a prior written notice to the parents after that decision, or I should say after they've made that refusal. So now I talked earlier how there are 7 required components that every prior written notice must contain. And I think it's so important. So you have 8 times when a prior written notice, 8 instances must be issued. Now there's 7 different items, areas in the prior written notice itself, in the document itself, that has to be completed by the school district or AEA. It's mandatory. These are not discretionary. And if you see any of those, if you get this document and you see any of those missing, then you need to ask them to complete it, or depending on the situation, you can challenge it. So let's go through. So number 1, a description of the action proposed or refused. So that's basically one of the 8. They propose to make a change to the identification of the student, or they refuse to change the placement of the student. So number 1 is always going to discuss what the action is about. And number 2 is, this is what's really important, that you want to make sure that there's enough detail, an explanation of why the district proposes or refuses to take action. So it's really important to understand the motivation, the motive for doing this action. And you want to make sure it's tied to something directly related to the student. Number 3, a description of each evaluation procedure, assessment, record, or report the district used as a basis for the proposed or refused action. This is important because you want to try to make sure that these decisions and these proposed actions are also as objective as possible. It's not just the opinion of one person. You want to be able to say, okay, these are the records that we looked at. This is the recent probe data. We did some classroom observations, talked to maybe the school psychologist. We got permission or consent to talk to the child's mental health provider. So there should be a detailed description of what they actually looked at. And before, that goes hand in hand with the proposed change, or like I said, action or refusal. Now, number 4 is a statement that the parents or guardians have protections under Part B of the Procedural Safeguards. And this means that it's not only just a copy of the description, but the parents have to be told where to find the information. So you're going to get a copy of this Procedural Safeguard manual that I talked to you at the beginning. And also, it's important that if you don't understand, especially if you're new to special education, what this means, I encourage you to slow the IEP meeting down, because they often will give you, here are your rights, and they kind of give it in front of you, and they'll say, do you have any questions? And if it's kind of like the first or second time that you've seen it, and there are, like, let me see, I'm actually flipping through it right now. There are 46 pages. So they have a duty and obligation to kind of give you a synopsis of what is contained in the Procedural Safeguard Manual. And if you have any questions at that point in time, because if they say, do you understand your rights? Yes, or these are your rights. I don't want there ever to be a situation where the school district or AEA use that against the parents. It's already overwhelming as it is to be an IEP meeting. And sometimes a parent is alone and there might be 10, 14. I've been in IEP meetings as many as 24 people around the table. You know, there could be that intimidation factor, but I think this is so important to understand what your rights are. And part of the rights that are in this manual are telling you a prior written notice. You have, after we discuss the IEP meeting, we have an obligation to send you a prior written notice, and you have an obligation to have time to consider it and have options to challenge it if you don't agree. Number 5, sources for parents to contact to obtain assistance in understanding the provisions of Part B and the procedural safeguards. For example, if you need assistance in regards to invoking your rights or even helping understand your rights, they're supposed to provide you with a list of contacts in the community in Iowa where you can seek assistance. For non-legal support, you can definitely call the Ask Resource Center. They have amazing non-legal parent advocates who are very well versed in the IEP process. You can contact Disability Rights Iowa. That'll be often another contact that they'll share with you to receive some type of legal assistance. And there might be some other attorneys listed on there. But the requirement is that the school district and the AEA provide a source for parents to obtain assistance in understanding the provisions. So you're not alone in this, that there's contacts in the community that could help you explain these rights to you. And it's important that you know that they have an obligation in school to share that contact information with you. Number 6, a description of other options that the IEP team considered and the reason why those options were rejected. This is really important because sometimes parents say that they make requests about one of those 8 categories and they don't see it in the prior written notice. Their request was rejected, but it wasn't in the prior written notice. So it's important to read the entire document and understand, did they consider all the options, or was it just to take it or leave it? Because there should be that collaborative discussion and all the options that were considered and rejected. And sometimes parents actually see a list of options in the prior written notice that were actually never discussed at the IEP meeting. And that should be another red flag, because then is that something that was just put in the prior written notice because it's a requirement, but parents were never part of that discussion. So I always tell parents, if you see that, then again, reach out by email to the school district or EA, whoever issued the prior written notice, and say, maybe we need to reopen the IEP meeting because there's additional information that was discussed outside the IEP meeting where the parents didn't have an opportunity to be a part of that collaborative discussion. And number 7, the last component that you'll see on the prior written notice, a description of all other factors relevant to the district AEA's proposal or refusal. So they can just maybe have considered in talking to some other people, talking to some previous teachers, or it could just be they're making a proposal. Maybe there's going to be a change in the boundary situation, or I have some students who in rural Iowa who maybe a new school district will be contracting for special education services. So there's all kinds of different, like there could be some other things that are related to the student that might be very important for the parents to know, to be included into the document. So as I said, once you receive, at the very bottom, I give you a tip, once you receive this prior written notice, carefully review all 7 items, because it's so important in the event that there's language in there that contradicts your understanding or recollection of what really transpired at the IEP meeting. Because if you made a certain request or if you made certain comments about a proposal that was brought up by the school district, and the conversation is opposite of what was reflected, it's slightly changed, or even, the whole meaning of the understanding of what the proposal is totally different. This is when parents want to make sure that this is why it's so important to read it, because you want to have an opportunity to try and rectify or correct the prior written notice before it goes into effect, before those changes go into effect. I always encourage collaborative relationship with the school district, between the parent, school district, and the AEA. So if it's something, there's not always an ulterior motive of why. It could be someone's understanding was completely different, or they only focused on certain facts or comments. So it's important that if you feel that there's a huge concern with the language, that what you thought they were offering and what they actually at the meeting and what you see on paper in black and white is completely different. I think it's important as a parent to contact in writing the school and AEA or the IEP team and kind of highlight the area that you have concerns about and see if it could be revised or a discussion. And like I said, maybe even have another meeting, because it could change the whole offer, the whole proposal, the intended action moving forward. So when are these changes typically made? This is very important. These changes are usually always discussed, during the student's IEP meeting, and the changes are going to be made either during the meeting or shortly thereafter. It is okay for, just like parents when they prepare before a meeting, it's okay for school districts. You want school districts and AEA staff, the IEP members, to meet and come prepared, maybe with their list of ideas for some proposed changes or stuff. So that's okay. But when they come there, you might see a person start working on a prior written notice, and that's okay too, because you're having this collaborative discussion. Sometimes it's important to kind of capture what was said at that moment. Like I said in the previous slide, sometimes when you wait too long to do a prior written notice, you might forget some of those salient details or comments that were made. So I often will see an IEP member working on the prior written notice during the meeting. Or like I said, shortly thereafter, because you want to make sure the longer that time goes by, unless you have a recording of the meeting or someone took extremely detailed notes, sometimes important facts may fade away, or you might not remember all the really salient details. There could also be occasions when a change occurs as a result of an amendment to an IEP without a meeting. Even if they have a proposed change without a meeting, and this always has to happen after the annual IEP meeting, you can't make these amendments or these changes prior to the annual. You have to still have an annual IEP meeting. But afterwards, there might be something that doesn't require the whole team. It might be, we had talked about this accommodation we forgot to put in. We want to make sure that we include it into the IEP. There's no concern. Everybody was agreeing. You already had the meeting. It was actually even mentioned at the meeting, or else somebody came up with it shortly afterwards, but it doesn't really change. It only enhances the student's FAPE. It doesn't affect the student. Parents, everybody agree. It's okay to make certain changes. It's very limited though, very, very limited outside of an IEP meeting. But even if that's going to be related to FAPE, like for example, you're changing the services, you're increasing the services, because in this example, you're adding a new accommodation to the IEP, then a prior written notice is still required. I just talked about this in the previous slide. The circumstances in which, like I said, it could be changed are very limited. And even though the decision to maybe, like I said, an example, to add the new accommodation after the IEP meeting, the school district and the AA is still required to go through the whole formality of the prior written notice process, which means that that decision is going to fit into one of the 8 categories, and that was a proposal regarding FAPE. So that was number 4 that we talked about out of the 8. And they still have to complete all 7 of the required elements in the prior written notice. They have to detail those. It still has to be in writing, and it still has to be issued to the parents. And again, I mentioned this earlier, if you do not understand, say you thought when they're asking you about this accommodation, you thought it was for one thing, but when you get this new prior written notice and you realize, you know what, that was not my understanding when they asked me if we could change the IEP without rejoining and convening another meeting, then it's strongly recommended that in writing you reach out to the school district and the AEA. You request an IEP meeting to further discuss before any changes are implemented. Because at that point in time, just because it's in writing in a prior written notice, you need to let them know that there was a misunderstanding. You might have agreed to it. However, now that you actually see how it's worded in the prior written notice, that's not your understanding. You had a totally different interpretation of what or how you thought that accommodation was going to be implemented, and you want to have an IEP meeting to discuss that proposed change of service for your student. Now, what if my child doesn't have an IEP? This is kind of near the very beginning of the presentation. There's a couple of situations. For example, we talked about they're doing a disability suspect review. And so technically the student doesn't have an IEP, or you have a student who might be struggling with reading or writing, and the teacher wants to make a recommendation perhaps to do an evaluation in a certain domain area. So that student won't have an IEP yet. So there are situations, because I know I've been talking a lot about at the IEP meeting, you kind of go to the IEP meeting, you discuss the student's progress, what their needs and services are, if there's any proposals or refusals, and then after the meeting, you're going to get the prior written notice. However, there are some exceptions where the student will not have an IEP yet, or maybe never, where there's still a legal requirement and responsibility and obligation of the school district or AEA to issue a prior written notice. And again, I provided the 2 examples that I discussed at the beginning of the presentation. This is another procedural safeguard protection. I kind of briefly mentioned at the beginning, there's about 10 that Congress had put together for parents to ensure that they have protections, they have procedural safeguard rights. The prior written notice requirement has to also be in an understandable language. Understandable language is another protection that is afforded to parents. And that means it has to be language that is understandable to the general public, but also in the native language of the parent or guardian, unless for some reason it's clearly not feasible to do so. Whether it be a language that they're not able to find an interpreter for, I'm not really sure. I've never really had a situation, I'm going to be honest with you, where I've been notified anyways, that they were not able to communicate. So whether it be any type of mode of communication, however the parent or guardian receives communication, whether it be in native language, whether it be in Braille, whether it be sign language, different types of devices, assistive technology devices they might need in order to receive the communication. In any event, the responsibility is for the school district and AEA to ensure that the prior written notice, this written explanation of either a proposal or refusal, and all those 7 elements are provided to the parent in a manner that the parent understands, so then they can make a meaningful decision whether to, if in the event, to challenge those proposals, or even, like I said, they understand what's going to be happening for the student, even if they don't. And sometimes there are situations where it does have to be done orally, but also confirming that does the parent understand what was just provided to them, the information that was just provided to them, asking a few more questions, because a lot of these, like FAPE, you have all of these terms that are not common everyday terms to parents. And it's important that whatever you're sharing with them, it's just not a regurgitation, but that the school district needs to make sure that the parent understands the information that is provided to them. So now, what does the law not specifically require? You won't see a date at the top of the prior written notice in terms of when it was generated. Sometimes there's a date at the bottom that says it's printed or copied on this date, which can change depending on which staff person has access to that record. But there is no date that's on the top of when it was drafted or generated. The law does not require that the school district or AEA confirm receipt of the prior written notice. So they can send it to you, but they don't have to make sure that you got it. So I always tell parents at the IEP meeting, discuss what manner you would like to receive the IEP, because if you say email and it goes into your junk mail, the school district technically did issue you the prior written notice if you want it in an electronic format. So they don't have to confirm that you got it. And also the parents, there's no legal obligation for the parent or guardian to acknowledge that they received it. So basically, once they send it to the parents, that's pretty much it in terms of the notice provision of what notice means. And then they also don't have the right to request information be noted in the prior written notice that's not mandated by law. So if parents are making a request that does not squarely fit in one of those 8 categories that we talked about individually, then they don't have a right to make sure that that request or mandate that request be written into the prior written notice. For example, maybe a parent thinks it's really important that they make a request for the child's diagnosis to be included in the IEP. Sometimes there are school districts that do not want the child's diagnosis included in there. They might put it in a behavior plan or a health plan or a safety plan somewhere else. And so it could be the IEP that they put it in, but they don't have to. They can discuss it, whether it's accepted or rejected, but that particular request doesn't have to have its own separate item that has to be addressed in a prior written notice. So when should the parent expect the prior written notice? We talked a little bit about this already. The law does not mandate that a prior written notice be provided within a certain time frame. So there's nothing in that Congress said, okay, they didn't want to have that hardline rule because there's certain decisions that might not need to be invoked or implemented sooner than others, or certain times, depending on the resources of the school district or AEA in getting out the prior written notice. They just didn't want to hold their hands behind their back to a certain time frame. And then, so I thought, well, what does the Iowa Department of Education, what do they have some guidance? And they do. They say, well, it must be given to you in a reasonable amount of time before the district or AEA implements that action, but after the decision on the proposal or refusal has been made. So reasonable, very subjective. So what's reasonable? Well, again, that I kind of dig down a little bit deeper, go into some district court cases around the country. And some circuits say, well, reasonable. I think some judges have said 10 days is reasonable. Another judge has said, 12 days is reasonable. So again, different circuits even have different amount of days that they think is reasonable. So then what did I do next? I went, okay, let's go to the Office of Special Education. Sometimes you hear that acronym OSEP. Well, they had some guidance. And I think it's important to put this in there as well, because districts, I'm going to just read it quickly. Districts should use common sense when timing the provision of written notice to a parent regarding a proposal or refusal to initiate or change the provision of FAPE. It's best to wait until the conclusion of the IEP meeting to avoid any appearance of predetermination. At the same time, the timing of the notice should be such that parents have enough time to assess the change and voice their objections or otherwise respond before the change takes effect. So parents need to have the notice after the discussion, right? After the IEP meeting, after they had the discussion, and then they need to have time to make an informed decision, a reasonable amount of time. And also, it is common sense for the parents to want to maybe contact an attorney, or maybe discuss it with some non-legal advocates, or maybe have a chance. I've had some that it was really critical based on the types of things that were being offered or refused, that they needed to contact their doctor, their child's medical team, or maybe their private speech therapist. So they need to have a reasonable amount of time so they can make an informed decision, do their own contemplating, and decide what their options are and before moving forward. So prior to leaving the IEP meeting, so we've got some tips here. So we want you to be proactive. So before the IEP meeting concludes, before people start standing up, like before they say, okay, if they say this is the conclusion of the meeting, just say, put your hand up and say, I have some questions I want to ask before anyone leaves. You want to find out, when are you going to receive the prior written notice? Because no doubtedly, you usually don't have an IEP meeting where everything's 100% the same. There's always going to be some types of changes, because if everything's 100% the same, that's a red flag that maybe the goals, if they didn't make any progress or there's no changes that need to be made at all, or any concerns, then maybe I'm always kind of concerned that it might be just a cookie cutter IEP, or maybe the goals were too challenging, maybe the goals were unrealistic. There's just things. So there should be always some type of changes. So ask when you will receive the prior written notice, and ask who will be issuing the prior written notice. I had instances where, they were asking the wrong person, and internally, the staff never communicated with each other. It kind of fell through the cracks, and it was a while before getting a copy of the prior written notice. So ask on the record at the meeting who will be issuing the prior written notice. Write that person's name down. Make sure you have their email address. And also, I mentioned just a few minutes ago how you will be receiving the prior written notice. Are you going to get it first class mail? Are you going to get an email? Are you going to get a hard copy in your backpack? Because remember, it has to be written notice. And even though email is considered written notice and you can print it out, so like I said, if you choose email and you haven't gotten it in a while and they said they sent it, make sure you check your junk mail. But either way, I think it's really important to have that discussion in front of everybody of how you want to receive the prior written notice. And also, prior to ending the IEP meeting, and this is really important, and I know a lot of parents have not done this because they're not as familiar with the prior written notice, but they will be doing this moving forward. Ask the school district and AEA before you leave, before you conclude the meeting, to say, let's go and have a quick discussion about we have the itemized list of all the proposed changes or refusals that are going to be written into the prior written notice, because it should not be a surprise, or it should not be a sneak attack, or sometimes it should be openly. It's a collaborative discussion. So then this way, when you're getting the prior written notice, at that point in time, if you have this big ask at the end before everyone leaves, then there should be no misunderstanding or misinterpretation when you actually get the document, because you would have had that discussion at the time with the whole team while everybody was still there. Because even between IEP members themselves with the AEA or the school district, I've seen that someone has made a proposal and the person who may be taking the notes did not understand it the same way. And that's just an innocent thing, but that's why it's important that everybody's on the same page, and there should not be multiple interpretations about a proposal or refusal. It should be clear to everybody. And it's something that if they say we don't have time, then ask to just say, I don't want to close the meeting then. I want to keep it, either we reconvene, or somebody after this meeting sends an itemized list to the whole team of what the proposals are before it goes, because it's so important. They should give you that time. Out of courtesy and respect, this is important. This is all the best interest of the student. So it should only be like 5 minutes. Everybody should make the time so everybody, like I said, has a clear understanding of what was offered. It doesn't mean everybody agrees. That's a big difference. I want to make sure you understand that. You don't have to go into rehashing. Not everybody's going to always agree on the proposals or refusals, but you want to make sure you know what's going to be listed on the prior written notice before you leave the IEP meeting. Now, what if the parent doesn't receive a prior written notice? Well, the prior written notice is a federal requirement. I mean, they have to provide it. The school district and the AEA, who's ever responsible for that particular team, they have to issue a prior written notice. If a parent hasn't received it, I always tell parents, like I said, you want to continue to have that working relationship with the IEP team. So if you don't get it right away and what's reasonable, like I always tell parents, if you forgot to ask, or say if you did ask at the IEP meeting and they said, I can get that to you by the end of the week, it's Tuesday. So to you, you're thinking the end of the week is going to probably be like Friday, you'll at least give it to Friday. Monday comes and you don't have it, then, I always encourage parents, send an email. Don't call because you want to have that written documentation. Send an email to the person who's responsible for issuing it and saying, I have not yet received a copy of the prior written notice. Can you please let me know? Will I expect it today? I think it's important that you put it in writing, you document that you have not yet received it, because you never know. There could be a situation where you do have to challenge it, and that not receiving notice is a violation, and that is something that you might need one day as a piece of proof in front of an administrative law judge or a district court judge. So it's important that another reason why you do it in writing. Now, if they refuse to provide the prior written notice or attempts to, or the school district is going to go ahead and implement the IEP without giving you a prior written notice, they're going to implement the changes before you receive it and have an opportunity to review and challenge. But anyways, what you can do if you don't get a prior written notice, parent, one of the options is to file a state complaint. And I think that's important because state complaint oversees compliance of the law. And so, for an example, not every situation where you don't receive a prior written notice, it could be a procedural violation, means that, okay, they didn't follow the rule, but is it a substantive violation where the child was actually harmed? For example, they want to conduct an evaluation, a speech therapy evaluation. So they have a meeting with the parents. The parents were fully involved. Parents agree, they think it's warranted. They go ahead and sign a consent form to be evaluated. The parents are part of the evaluation process. They're interviewed. They discuss their concerns about their child's speech and language and pathology concerns. And then they go ahead and they actually do the evaluation. Now, even though that's a procedural error, they should have received it prior written notice. They didn't. They didn't issue one. They went ahead and did the evaluation before issuing the prior written notice, and that is not the right order. You have to issue the prior written notice first, wait a reasonable time, and then continue with the evaluation. However, the parents, because they're involved in the whole process, very detailed, they consented to it. They started doing the evaluation with them. There's no concern. So we call that in the legal world harmless error. So technically they weren't compliant, but there was no harm to the parents. There's no harm to the student. And everybody was on the same page and everybody was 100% in agreement of what was happening. But does that make it right? No. If you realize you never received, even though there's harmless error, but sometimes, you know what, I've had a parent say, I don't recall receiving a prior written notice in the last 2 or 3 meetings, and they go through all the documents and they go through all the emails. So even though they don't have any concern, they're kind of on the same page with the IEP team. If you see a trend, if there's a trend and a pattern, even though there might be harmless error, it could be that if that parent's not receiving a prior written notice, maybe a lot of parents aren't receiving, especially parents where situations where they might need to challenge something before it's being implemented. So I tell parents, if you see a pattern, that could be a situation where, and you've made a request and you're not getting them, there could be a situation where that would be warranted for a state complaint and have a special education attorney from the Department of Education determine whether a complaint is necessary or investigation, because it could be a huge systemic issue behind the scenes with that particular school district. So it's important, even if you agree and they start, you can remind the school, I need the prior written notice. It needs to be part of the student's educational file. We have dispute resolutions. This is really important. This is going back to that Procedural Safeguards manual. This manual really does outline all the different situations that the options that the parent has if they want to challenge a proposal or refusal. So you want to go ahead and you want to read that manual. And if you can't find it, you can call Ask Resource Center. They can either mail you one or they can send you a link to one, but it's so important because there's a lot of really good information, and it tells you, not only does it tell you the steps of how to process it, but there's also some sample forms in the back. So there's two things that you could do, and these are the two that I usually just talk about. The notice is going to give you an opportunity, if you want to challenge it as a parent, to either seek resolution through a state mediation request or a due process hearing. So that's another reason why you have to have that prior notice before implementation of the IEP, because you want to be able to make an informed decision. If you have concerns, if you want to challenge it, you want to make sure that you have time to seek advice from an attorney or other individual to assist you with that decision, or even maybe representing you in that decision. But those are the two dispute resolutions that I work with parents, are state mediation and a due process hearing. Now, I talked a little bit, very briefly, and I think it's really important to add this slide in. When we say, when should you get the prior written notice, you need to get the prior written notice either at the end of the IEP meeting or shortly thereafter, a reasonable time. If you get the prior written notice at the start of an IEP meeting, like sometimes they send you, I have actually seen this is why I put a slide in, where they send you a copy of the draft IEP, and then there is a completed prior written notice with all 7 elements saying we discussed this, and this is what's being offered, and this is what's being rejected before the IEP meeting even started. That's a huge red flag. That is a different violation. That's a predetermined violation. That's a legal term, means that decisions were made by the school district and or AEA without parental input or consideration. Because that's another procedural safeguard, is that parents have a right to be present at the meeting, and they have a right to have input and have it meaningfully considered. It doesn't mean the school district and AEA always have to agree with you, but you have to have the opportunity, you have to have that forum to be able to share your ideas, share your concerns, and collaboratively discuss before any proposals or rejections are made. So if you ever have a situation where a prior written notice is distributed at the start of an IEP meeting, that is, like I said, a huge IDEA violation, and that you might even want to consider seeking some legal advice or talking to even a non-legal advocate about, do you want to continue, maybe rescheduling the meeting because you feel like all these decisions have been made ahead of time. So that is just, like I said, that's a very big concern, and I have seen it with my own eyes. I've been in an IEP meeting when that's happened. So just be aware, predetermination is a violation of parental rights. Now, how can I use the notice to better participate in the IEP process? I think it's important because parents sometimes, like I said, you can get intimidated sometimes, or the conversation can get steered away to what your interests are and what you want to discuss and some of the proposals that you want to make. So I always encourage parents, if you have specific proposals that you want to make, or that they're going to come to you with certain rejections, or you want to reject something, you want to make sure that these requests, these action items, are put in writing and you present them to the IEP team. I would say, if possible, present them even before, because then they have an opportunity to see what your position is. The way I practice and the way I work with my parents, I always support transparency. People that know me know that I don't like the I gotcha. If you've got ideas, or if you've got requests, that I always tell parents, let's put them all on the table, because this is for the best interest of the student. This is what you're asking. This is what your action items are. So let's give them advance notice, because sometimes they might have to consult with other experts or other sources to be able to have an informed and meaningful discussion with the team. Also, make sure that your requests are part of an agenda. I talk to a lot of parents who say they have never really been given an agenda, or never asked for their input if there are any items that they wanted to discuss on the agenda, if there is an agenda list. I always tell parents, be proactive. Tell them that you want an agenda and that you want to be part of the agenda, and you want to make sure that your action items, your requests, make it to the agenda. And you don't want it to be at the very bottom. you want it to be discussed earlier, because we all know that there's times when people from the IEP team might have to leave a little bit early. Sometimes they might have to step out for maybe an emergency that's happening in the school. It's really important to say you want it to be part of the action item. And if you can, maybe when it's time for the parent, say you want to make sure that that action item that's on your list is tied to the discussion at that appropriate time. And also making sure that before you leave, remember we talked earlier about, hey, let's ask them, now we've had our meeting, there's some proposals, there's some refusals. Again, rehash what is it that you're going to be putting in the prior written notice, because now you have an idea of what these 7 requirements are, and you want to make sure if they're already making a decision instead, if they have already made up their mind no, then they should be able to tell you all the information, the details on all those 7 requirements. Take notes as they're sharing them with you. That is something that they should be able to provide to you. And if it's requests related to the identification, evaluation, reevaluation, placement, or provision of a FAPE that were not approved. So one of those 4 categories, when we talk about there's 8 areas, there's 4 categories in terms of when I just mentioned placement, FAPE, reevaluation, identification. If it's something that's in those categories and they did not get to it, they tabled it, you have got to make sure that you ask for a written notice, because if it's so important that if they're even going to refuse to discuss that option, you want to have them tell you in the written notice that the IEP team refused to discussion. I think, and if you don't have time, I always ask parents, you know what, ask to keep the IEP open and reschedule another meeting, because it's so important, because all those 4 areas are part of your procedural safeguards and rights. If they don't have time to talk about them, then that means they didn't schedule enough time for the meeting, or there was more information that needed to be gathered to make an informed decision before someone could make a proposal or even reject it. Try to reschedule another IEP meeting, but make sure, even if they do that, you get that written notice. The notice says that we did not get to this proposal or this action item, and we're going to reconvene at another meeting. Stay put. We're nearing the conclusion of our training, and this is really important. When the parent or guardian requests a mediation, a state mediation, or files a due process complaint with the Iowa Department of Education, it's going to trigger the stay put provision. I'm not talking about an AEA mediation. I'm just talking about mediations that are filed through the Department of Ed or a due process through the Department of Ed. Stay put. And what does stay put mean? It's exactly, just think if you can envision having like a crossing guard and having your hand up, and it means that everybody stops. Like nobody can make any changes or implement the proposed IEP until the parent resolves the differences and identified issues. So it means that everything, it's almost like frozen in time. That's the best way to describe it. But the only way you're going to get that, put the hard brakes on and freeze everything in time, is that you actually have to implement or take action. You have to either file a state mediation or a due process complaint. Sending an email to the school district or the AEA is not enough to invoke stay put. You actually have to do a dispute resolution. One of the 2 dispute resolutions are the mediation or due process. Once you do that, stay put is going to be invoked. That means whatever IEP that you have at the current time is going to be implemented. You're going to continue with the current IEP. Nothing's going to change. And then the proposed IEP, the newly proposed IEP, is the one that's going to be in dispute that you're going to discuss at the mediation or the due process hearing. And then the statute of limitations, I always like to mention this, that under the IDEA, a parent or agency must request an impartial due process hearing within 2 years of the date that the parent knew or should have known about the alleged action that forms the basis for the complaint. So you have 2 years. However, a lot of the times you want to file immediately. Like if there's a concern that you don't want something to go into effect, because you're going to see on the prior written notice, when you go through the whole notice, the only date that should be there is the date that the IEP will going to be implemented. That's usually at the very, very bottom. After the 7 elements, it'll say, when will this be implemented? You don't want to wait. It's going to be more challenging if that new proposed goes into effect. Then you challenge it down the road. You still can, because you technically have 2 years. But if it's something, for example, like say if the school district and the AEA, the whole IEP team made a decision, a collective decision along with the parents, that they could not offer FAPE to the student in the public school, that they needed a therapeutic placement. Student goes. It's determined that the year later, because remember we talked about you have to have an annual IEP meeting, the school district and the AEA or one or the other decide that they no longer need that private placement. However, the last IEP takes an effect, and if it says in the IEP that the placement is at such and such, or this therapeutic placement, if you invoke stay put, then the student remains at that placement until your disagree or your differences have been resolved, whether that's through mediation or due process. So do you see how you don't, and if you don't file before the date that they implement the new proposed IEP, which means to bring the child back, or propose lesser restrictive, like maybe another facility that's a different LRE, it's going to make things more challenging for the parents and the students because the new IEP will have gone into effect. So it's so important to look at the date when it's going to be implemented. They're giving you notice. They're going to say, from this date forward, we're going to be implementing the new IEP unless you challenge it. If you don't see an implementation date, and I've actually seen some that were blank, I think it's really important that you contact the school district immediately, or whoever your contact person, whoever issued you received the prior written notice from. It is so important because that is unfair, because that's a requirement that they're going to give you reasonable time. You get it within a reasonable amount of time, but you need to know, because if they are planning to implement it immediately, that is not reasonable. Unfortunately, you would have to challenge it since there is no certain date, but 24 hours isn't reasonable to have a turnaround time, especially with certain types of issues that might be presented or certain types of disagreements. So it's really important, again, when you get that prior written notice, is go through the whole thing immediately, and if you see anything missing, contact them, especially the date, because the implementation date is going to kind of be that barometer in case you need to have some discussions with counsel or some non-legal advocates. You want to be able to have a fair opportunity and time to have a discussion to make an informed decision. So, and again, so important that stay put, the breaks don't happen until you actually do file a dispute resolution. What are the options of a state mediation or due process with the Iowa Department of Education? That is the end of my presentation of prior written notice and a review of your parental rights. And usually when you get your prior written notice, a lot of the times it'll come with the final copy of the IEP. So a lot of times parents will say, I didn't get my prior written notice. I always say, go to the very last page, because sometimes, especially when you have a reevaluation, you'll have a 40-page IEP. You might have a functional behavior assessment. You might have a behavior intervention plan. You might even have a health plan. And then the prior written notice is usually the very, very, very last page. So sometimes they're actually all together in one document. So carefully go through all of the pages of the document that you received. And then if you still don't see the prior written notice, then immediately contact your contact person on your IEP team or whoever said would be issuing it and ask them for it. It could be that they needed some information, they needed to consult with someone before they made a final decision. Could be possibly not be there issued yet. But a lot of the times, the prior written notice I've seen have been attached at the end of the document, and it just says final IEP. It doesn't say in the communication from the school district or EAE that it's a final IEP and the prior written notice. So that's why it's important to review every single page that you receive. I hope you've learned something new about prior written notice, and I thank you for this opportunity.
Edie, it was Fantastic. Thank you. Such great information you've shared with our families. We have had a couple of questions come in, so I'm going to give you the first one. What happens if the parent receives the prior written notice and the date of implementation has already passed? For example, it was dated the day of the IEP meeting. I think this sometimes happens, and it's likely not an intended error. Should the parent simply contact the IEP team and request for the implementation date to be changed to allow the parent time for review?
Yes, definitely, because number one, you still want to make sure that that date is changed. There could be a situation at the IEP meeting where they actually openly talked about it. They said, like, for example, if they were going to do that speech evaluation, that they're going to say, okay, we're going to go ahead. The evaluator has a space open tomorrow to start the evaluation. Everybody's in agreement. And the parents are like, we're going to draft a prior written notice right after this meeting. We have consent from you. And there could be a situation where everybody collectively agrees that they want to start with that evaluation immediately. So it's okay because there's that collective discussion. Does that make sense? However, the concern is technically you could have a quick turnaround. I'm going to be, in a situation like that. But the problem is when there's been an IEP meeting and there is some disagreements. It is not 100% mutual. All the decisions that were discussed are made. There's not 100% consensus, especially if it's the parent that's not consenting or consensus with the school district and the AEA. Then in all fairness, they do need to say that they need to put it in writing to the school district, asking if they would amend the prior written notice to adequately reflect a reasonable time to have them review it so they can consider their procedural safeguard options. I think that's so important that they do that in writing because it also puts the school district on notice that they should not be and they also want, if they actually did start implementing the IEP, they want confirmation that the new proposed IEP has not been implemented yet because they did not have time to reasonably review. These are important because if they haven't received, sometimes they've received a prior written notice months later because when I've worked with them, they never got one and they actually draft one. But there's, again, harmless error because everything was going smoothly. It was just me saying, hey, where's the prior written notice? They contact the school district, realized that one wasn't drafted. But again, it was harmless error because certain things were already being implemented that were okay. It might be something new that was after the IEP meeting that had no bearing on that. It's just so important that the student's educational record be complete. And like I said, you can't have one without the other. If you have an IEP meeting, then you need to have a prior written notice issued at a reasonable time afterwards. So I want parents to always think of the two: IEP, prior written notice, PWN, IEP, PWN. They go hand in hand. They're a couple.
Perfect. Good reminder. And another question, how should I know if the reason that is given in the PWN is worth challenging?
Well, it depends on really what the action is for the student. If it's for administrative convenience, that's against the law. Congress is saying that there's very, very, very few exceptions where administrative inconvenience would ever override a student's special education rights. And so they can't say, well, we don't have the staff, or if it's determined that the student needs a paraprofessional, then they have to find the staff. Of course they might need time to place an ad. Again, it goes both ways. You have to give them a reasonable amount of time to take the steps to find that. But they just can't say, no, we're going to refuse because we just don't have the staff to do that. Especially if it's determined there's enough evidence to document that the student needs that extra staff support. So I guess it depends on the circumstance and how it might harm the student. So, okay, they gave you a reason, but if the reason is, like I said, administrative inconvenience, that usually doesn't cut it with judges. And there's a lot of case law out there. And there's a lot of guidance out there saying that they can't do that. Administrative inconvenience cannot trump a student's needs for services.
All right. Well, Edie, just fabulous. The importance of prior is so critical. And you're right. As they do the IEP, think prior written notice. They go hand in hand. It's not just one, it's both. And we can help reinforce that at ASK. So thank you again for sharing your expertise. Excellent information. And we look forward to visiting with you again. Thank you.
My pleasure. Thank you.